mention?
May you please your Lordship, I beg to mention item number 20 of today's list. The conducting counsel department is indisposed.
List after 3 weeks. On the prayer, what's your name? Your name?
N. Tiwari. N. Tiwari.
N. Tiwari. So this is a matter for 3 weeks, as the arguing counsel stated to be indisposed. Yes.
May please, Your Lordship, I beg to mention item number 9, Your Lordship.
Item number?
Item number 9, Your Lordship.
Number 9, Lordship. Hearing first item here.
Lordship, due to bereavement in his family, Lordship, that's why he could not be here today.
Supplementary list?
No, Your Lordship,
No,
daily
main
list.
list.
Number 9 is for hearing?
Yes, Your Lordship.
Part her.
Oh.
Across it.
Yes, Your Lordship. Lordship, due to bereavement in his family, Your Lordship, that's why.
3 weeks. I'm looking forward to your assistance, this matter, how to resolve it.
I'm trying my best.
Yes?
Try my best.
I'm sure you'll do more in your best. Anyway, after 3 weeks, yes.
Much obliged.
Please, Your Lordship, I beg to mention item number 17.
17.
Can you give 1 week time, Your Lordship?
17. Let me hand it to you. Shubha Kumar, Sarkar. This after 3 weeks on the request of the counsel petitioners.
My please, Lordship, is supplementary number 3. Hearing matter, my Lordship may allow me to withdraw the writ petition with the liberty to file afresh. A certain development take place.
Yes,
Number 3.
Mr. H.S. Senior Counsel, on behalf of the petitioner, please that he be allowed to withdraw the incident application with liberty to file a fresh issue advice. Yes. Stop. Prayers allowed. So next line, the matter stands closed on withdrawal. However, liberty as prayed.
Thank you.
Yes.
Yeah, please, Your Lordship. I beg to mention item 21, Your Lordship.
21.
Yes, Your Lordship. The conducting counsel, Mr. V. Kumar, is not able to appear as he is having some personal difficulties.
3 weeks, yes. No objection, yes.
Obvious, Your Lordship. Your Lordship, can I mention item number 10 and 11?
Number?
10 and 11.
10, 11. Where's Mr. Manta?
He's still not
well. We'll go after 3 weeks because this court won't be there for another 3 weeks, yes.
3
Yes, after
weeks.
3
Okay.
weeks.
Please, Your Lordship, I
Yes.
beg to mention item number 15.
1-5.
Yes, Your Lordship. The granted counsel, Mr. Piobin, is out of station, Your Lordship.
My Lord, I appear for state respondents. I have no objection to that.
Yes.
Similar prayer on item number 18, Your Lordship.
Number?
18.
18. 18, you are there?
Yes, Your Lordship.
You
No
for the
objection.
petitioner?
Yes, Your Lordship.
And for the respondent number 5, Your Lordship.
3 weeks, yes.
Highly obliged.
Highly obliged, Lordship.
Supplementary list, item number 1.
Yes, Mr. Sheikh.
Contempt, Lordship. That is the order is at page 7, Lordship. Here only the direction was given to
Where the
make the
direction?
payment of gratuity along with the interest.
Number 7, page 7.
Page 7, Lordship, yes.
Ranjit Kumar Koch. Yes.
Directed to pay the gratuity along with interest at the rate of 6%, Lordship. So far as the principal amount of gratuity has been paid, Lordship. Although there is some discrepancy with regard to the amount, Lordship, because they have calculated the gratuity amount as per the new notification, my Lord. Since I have retired in 2011, I will govern by the earlier notification, my Lord. But whatever they have
For the
paid,
amendment of
yes, Lordship. Whatever they have paid, but the direction was given with interest, my Lord. That has not been complied, Lordship.
part compliance only.
Yes,
You're entering appearance.
No, I'm not entering
Straight away.
appearance, my lord.
Draw notice.
My endeavor was, my lord, that I was instructed that there appears to be some calculation mistake. So I would pray, my lord, if the matter is taken up after 2 or 3 weeks, we will try to resolve it, my lord. Because payment had been made substantially, but there's some...
Heard Mr. S.A. Sheikh, counsel petitioner, issue notice. Stop. Next paragraph, Mr. S. Deb, who is present, though not formally appearing for the respondent, has made a submission that part compliance with order, there has already been a part compliance order, and maybe with the
there's a mistake in the calculation.
And there might be some discrepancy in the calculation, which has resulted in the contempt application. Stop. He's permitted to seek instructions. Just a matter after 4 weeks. Yes.
Highly obliged.
On so.
Item number 2.
What is this?
Wait, please, Your Honor. Your Honor, Your Lordship, through this petition, I am praying for grant of financial upgradation by way of ACP and MACP. Lordship, if Lordship allows, I will present a brief history of the case.
No, this matter didn't come for the court before.
It has, Lordship.
Where's the order?
It is there in annexure 10, page number 60, Lordship.
Page number 60.
60.
Page 60.
What before it came from what?
The earlier I had approached this honorable court, and honorable court was pleased to issue an order giving effect to my past service to be counted for the recalling of pension under old pension scheme.
Oh, now it's different subject. Different cause of action.
Different cause of action, Lordship.
So now he's paying for MACP, my lord, to
MACP.
modify. My lord, I'll take notice on behalf of respondent 1 to 5, my lord.
1 to 5.
There are 6 respondents, so I'll
6 is whom?
My lord, MTDC, Managing Director, MTDC.
Yes. That's also issue notice. Returnable in 4 weeks. Next line, MSR Koni is present, accepts G11 and GA presence is present, except those on behalf of respondent 1 to 5. Petitioner takes steps to issue the notice to respond number 6 within 3 days. Yes, on so. Yes, on returnable date.
Main list, item number 1.
This is an arbitration matter. My learned friend has filed his notes of argument. We are still in the process of trying to complete it. I was praying if your lordship kindly give us a week's time.
Take 4 weeks' time. Because
your lordships are not available.
Yes. Mr. K-Paul pays for 4 weeks' time to complete the necessary requisites.
Item number 2.
As it is also to I won't be able to render the judgment because I will not be here for
your lordships are not. Grateful.
May it please your lordship. Lordship, in this matter I've already filed on behalf
yes,
of
you already filed last time.
2 and 3, your lordship.
What about 3 and 5?
Your lordship, for respondent 5.
3 and 5?
Your lordship, I filed on behalf of 3 and 4.
Okay.
Now for the BDO, your lordship, I'm praying just for a week's time.
1 and 2 you're not filing?
No, your lordship.
3 you already filed?
Yes, your lordship. 4
then,
also.
No, last time you say that you filed or we already filed behalf of number 4.
Yes, your lordship.
Correct?
Yes, your lordship.
And then you prayed that you're allowed to file on behalf of number 3 and 5.
Yes, your lordship. I've already filed for 3. And
now for 5.
For 5, your lordship, just a week's time.
MS Ailingwa submits that submits that the affidavit on behalf of number 3 has since been filed and pays that she may be allowed further time to file the affidavit on behalf of respondent number 5. What only?
Well, 6 to 8 is MAC. I already filed my affidavit on the 18th of April.
Yes. MS Al Kolni, next paragraph. Counsel submits affidavit since has already been filed by respondent 6 and 8. What about Mr. Karmoshun, correct? I'm sorry. You already filed. Yes, Marvin's present behalf of 930 through the affidavit filed. What about rejoinder to the affidavit? Last time she had asked for time.
But once my friend filed the
yes, as paid by MS Ailingwa, further 3 weeks time granted for affidavit by respondent number 5.
Yes.
Just thereafter.
Item number 3.
Please, your lordship. In this matter, the union's affidavit is still outstanding, my lordship.
MSS Rumthau, Vice Dr. M. Muzika, 1 and 2. Raise funds allowed further 2 weeks time to file affidavit. What about the other two? All fine. The affidavit on behalf of other respondents have already been filed are on board. Yes.
Similar order for the next matter as well. Obliged.
Offline.
5.
Wait, please, Your Lordship. Your Lordship, I pray for some more time, Your Lordship, to file the affidavit in this matter. We've sought for additional instruction, Your Lordship, because in the matter there are two individuals with the same name, Your Lordship, who had taken part in the recruitment process. So we are trying to determine, Your Lordship, which is the...
Oh, you're the imposter?
Yes, Your Lordship.
According to them, Your Lordship.
But according to you, they're not the imposter?
No, Your Lordship.
Okay. So what instructions do you need?
Your Lordship, we are awaiting some documents, Your Lordship, so we can clarify which was the actual candidate who was recommended.
MSZ raise funds allowed further 2 weeks time to file necessary affidavits just thereafter and so on. So.
Obliged, Your Lordship.
6.
May I please?
Yes.
Well, in this case, there is 2 points, my lord. First, that the petitioner was not signed each and every page, and it was not presented by the petitioner. Thus, 2, my lord, due to it was also not pointed out by the registry, my lord, so this happens, my lord. And moreover, my lord, it is only a procedural left, my lord. It can be cured, my lord. Petitioner can, if he lordship allows, he can sign, my lord, each and every page. Secondly, my lord, they have taken the ground of limitation, my lord, that section 5 is not applicable.
Yes, not applicable. Yes.
That's from the judgments of Honorable Supreme, it is true, my lord. But somewhat, my lord, facts of my case are different, my lord, on 2 counts, my lord. First, my lord, that in my case, my lord, he has first lodged the complaint before the election commission, my lord. No action was taken. Then, my lord, he filed a FIR also. Police also did not take any action, my lord. Now, my lord, after filing this election petition, my lord, the election commissioner as well as the, my lord, respondent 3, he was the deputy commissioner, my lord. So, all these 3 have, my lord, filed the objection.
How can you seek to maintain that kind of, if those are actions, whatever you've done, independent of, Section 81? Now, and even then, and limitation, that no delay can be condoned, except in very special circumstances, because Limitation Act will not apply. Cannot apply. There are many judgments that say that. You can take recourse to Section 10 of General Clauses Act if you can satisfy the court that, that maybe on that day, suppose to file, you couldn't file. But by ordinary interpretation,
yes, ordinarily,
and so, I mean, limitation, it'll have to go.
My lord. But my lord, after all, my lord, these judgments of Honorable Supreme Court, my lord, precedents. So, if precedents are applicable, my lord, if the facts are similar, my lord. So, on facts.
By your own admission, you said that he did not come within time because he was pursuing other remedies, correct?
My lord.
So, then after you fail other remedies, you didn't come straight away petition, so what do you expect? 45 days is 45 days.
No, my lord. And secondly, my lord, the petitioner is neither, he was not the contesting, nor he, yes, my lord. Neither, my lord.
Of law,
neither, my lord, yes,
you are a seasoned.
But, my lord, he only wanted the action to be taken against the, my lord, erring candidate. That was not taken, my lord. That's only his.
The thing is that this is an election petition. It's not any other run-of-the-mill, application where court's discretion is large enough to accommodate these procedural lapses. We do not want to be hyper technical, like with regard to maybe applications are filed and all that we can overlook, but with regard to the requirements of law, that we are bound. So you take your choice. You want to argue it, we'll argue some other day if you feel that you can seek to maintain your petition. Otherwise, prima facie, I'm sorry.
Yes, my lord, prima facie it appears that if it is not applicable, but my lord, in some case, some judgments, my lord, it appears that Section 29 is, if the law does not prescribe any, my lord, the procedure regarding, my lord, the limitation. So 81 only prescribe, my lord.
Yes.
My lord, Section 81 only says, my lord, that it has to be filed within 45 days. Expressly, it is not barred, my lord. Express
86, please see
86, yes, it has to be dismissed, I know. But limitation period of 45 is provided, my lord, that, but my lord,
does not comply with 86.
My lord, but my lord, the RP Act does not say, my lord, that the provisions of Limitation Act are excluded. So, my lord, section.
You do not. It's by interpretation, Mr. Gaur. How can you say that we will act speak? Is it special legislation?
Yes, it is special.
Because what with due respect to your client, he has gone on fishing expedition, started fishing here, didn't bite, there didn't bite.
No.
Now he's come to this pond trying to fish, hoping the fish will bite. That's the only thing. We'll give an opportunity to argue if you want.
My lord, may I pray, my lord, that it can be converted into a writ petition, or I may be allowed to be. I may be allowed, because my lord, my only grievance was not that
you withdraw it and see alternate remedy. We'll give you that liberty.
That liberty may be granted.
Yes, Mr. J.C. Gaur, after hearing something, J.C. Gaur submits that prays that he be allowed to withdraw the instant election petition with liberty to seek alternate efficacious remedies. Not objected to by Advocate General.
Only one submission, man. Alternative efficacious remedy in accordance with law. If law permits, he's entitled.
How? If he comes to court, you think he'll court? We won't go in accordance with law. What are you implying, Mr.?
No, what I am trying to say, my lord, what he will say that your lordship has given liberty and pursuant to
in accordance with law. Yes, matters.
Lordship, and one more thing, your lordship has said that requirement of not now matter is over. Under section 81 and 83, there are two requirements, my lord. In fact, even there is a constitution bench judgment which says that if you have not mentioned true certified copy, that is a ground for dismissal because requirement is laid down in 81, my lord.
Right. Thank you.
Item 7.
Your Lordship, by the order dated 10th May, your Lordship had granted us time to file written objections.
Statements of objections.
Yes. So
statements of objections, yes.
Yes. So we are filing this objections as far as Section 86 of the Representation of People's Act is concerned. The registry, your Lordship, has said that to present this before the court, because as per the Guwahati High Court rules.
No, that Rule 10 says that it's under application, not in state. They should accept it. Anyway,
okay.
you present it. Yes.
All right.
You are Mr. Pandey.
Yes, Aditya S. Pandey.
Yes, Mr. A.S. Pandey is present in court for the respondent number 2 and has filed his written statement, which is accepted by court master, seem to be registered and kept on file.
Obliged, Lord. I'll give a copy.
Obliged.
Lordship, this is an written objections.
We will examine it.
Right.
Yes. Let them get a copy first.
Yes. Obliged, Lordship.
Item 8.
Nice name petitioner says.
My lord,
Respondents are yet to file it.
This matter is coming for the first time after motion, my lord. So I'm waiting for instruction, further instruction.
Enter appearance on behalf of respondents 3, 4, and 5.
So enter appearance with AAG or alone. This is the MIDC.
My lord, she is appearing as senior counsel, my lord. Madam T. Youngie will be appearing.
No, I mean.
I'm appearing with AAG.
Let make a submission. You are assisting who? You are assisting her. You are assisting alone. You see it, no? That I'm led by my senior in. I'm entering appearance led by my senior and so and so. Don't be scared. 3, 4, and 5. Yes. So the no 3 is MIDC.
My lord, yes.
4 and 5. That means.
All your lordship 3, 4, and 5.
Okay. Yes. How can she appear for the private respondent also?
She's not appearing for the state, your lordship. It's only for the
private respondent.
No, private respondent. This is made by name. Number 4 and 5.
My senior is instructed your lordship to appear.
They might have giving them a handle anyway.
Yes.
Yes, Mr. So has entered appearance and submits that she'll be led by her senior MSP Young in the matter. She prays funds allowed 3 weeks time to file affidavit. The MSR only has similar prayer, which is allowed this after 3 weeks.
Hearing item 12.
The matter was heard at land lordship. I was
don't remember anything.
regarding only two issue, Lordship, here. I say that they have initiated the proceeding after my retirement, and in that eventuality they cannot invoke the power to grant provisional pension to me, because the power to grant provisional pension lies with the government when the government employees before his retirement, before he retires. But the provisional pension, the power to grant provisional pension, the government has invoked after the date of my superannuation. Rule, Lordship, in the counter affidavit, my lord, they have.
Page 6 of the affidavit.
Yes, Lordship.
1 second.
Rule 9.
We are in 4. 1 second, 1 second. Just clarifying something. Appointment 13
I say whatever the power they have exercised.
Yes.
To grant provisional pension and withhold my regular pension was illegal, Lordship, because they have invoked the power 9, Rule 9, subclause 4, Lordship, page 7.
What is Rule 9 subclause 4? In the affidavit?
Yes, in the government affidavit, Lordship, page 7, Lordship.
Rule 9,
subclause 4.
filed by the respondent number. Okay, page 7.
Page 7, Lordship.
Page 7, Rule 9, right of governor to withhold withdraw pension.
In the case of a government servant.
Yes, okay, 4. Yes, read.
4. In the case of a government servant who has retired on attaining the age of superannuation otherwise, and against whom any departmental or judicial proceedings are instituted, or where the departmental proceedings are continued under sub-rule 2, a provisional pension as provided in Rule 64 shall be sanctioned.
You mean to say that the department should start before he retires?
Yes, Lordship.
Not be instituted after he retires.
Provisional pension can be granted
only if
against the government servant. Against the government servant. Lordship, I have retired on 31st January 2014. So, after 31st January 2014, I was not a government servant. I was a pensioner, Lordship. Although I was not given the pension, Lordship, but I was not a government servant.
Then you do not come with a deficient government servant anymore.
Yes, Lordship. Okay. So, now in order to show that the government servant should not get escort-free after doing some illegalities while in service, that is why the rule has framed. That is Rule 9A, Lordship. The preceding page, Lordship. Page 6.
Yes, just read.
Page 6 says, right of governor to withhold or withdraw pension. The governor reserves to himself the right of withholding or withdrawing a pension or part thereof, whether permanently or for a specified period, and for ordering recovery from a pension of the whole or part of any pecuniary loss caused to the government if in any departmental or judicial proceeding the pensioner is found guilty of grave misconduct or negligence during the period of his service, including the service rendered upon his re-employment after retirement. Here, my lord, that is why the government has framed the rule, so that the government servant, even after retirement, they should not go scot-free after doing all illegalities, Lordship. Here, they ought to have released my pension, and if there is a finding recorded by either in the departmental proceeding or in the criminal proceedings that I have caused some pecuniary loss to the government, then
it can be recovered.
Then can be withheld permanently or it can be recovered. But they have not done this. But they have invoked the power to grant provisional pension, which is not applicable in my case. The power can be exercised against the government servant while in service.
No. See, that means that while in service, okay, department proceedings have been drawn up. Okay, they're still continuing.
No,
you
Lordship.
retire.
No, Lordship.
Okay, I'm
Yes,
just
true.
just situation.
Yes, true.
You retire.
Yes.
Then those the departments continue. Now, in that event, you mean you're entitled to provisional pension.
Yes.
Then 4 apply that time.
Yes.
While a government servant, your DP would run out.
Yes.
Then you retired.
Yes.
Then, but not in the case because after you already retired, then you drop DP.
Yes.
That's your case.
Yes, my lord. My case is not DP, my lord. My case is criminal proceeding.
Okay,
but so far as criminal proceeding is concerned, Lordship, the word continuation is not mentioned. If the criminal proceeding is drawn prior to my retirement, that rule did not say that it can be continued.
How do you say that? Where do you find
Yes,
that?
Lordship.
You're making it very hyper-technical.
Yes, Lordship.
Yes.
In the case of a government servant who has retired on attaining the age superannuation or otherwise, and against whom any departmental or judicial proceedings are instituted, Lordship, or where departmental proceedings are continued. Here, so far as the judicial proceedings are concerned, the word continuation is not mentioned, Lordship.
How do you say that?
Yes, Lordship.
Are instituted. That means it will be have interpreted that way. That instituted, that means until they culminate. Then
no, Lordship. Here under are instituted under sub rule 2. Under sub rule 2. Sub rule 2 says.
Where are you reading?
Page 7, Lordship.
Yes.
Rule 9.4.
Where's sub rule 2? Sub rule 2 is in page 6.
Yes, Lordship. Next page, Lordship.
Yes.
Sub rule 2. Then in that eventuality, then the departmental proceeding can be continued as if the government servant has not retired, Lordship. But so far as the criminal
come again with judicial proceedings.
Yes.
You're trying to clarify. Yes. What is your judicial proceedings? Once instituted, that means only instituted. They should not continue.
They can continue, Lordship, but so far as I am not saying that they cannot continue.
Then?
But for continuation of judicial proceeding, if the proceeding is initiated prior to my retirement also, if it is continued, Lordship, then in that eventuality, the government cannot invoke the power 9 rule 4.
Why not? Now you're splitting hairs. Now you say that in case government servant is retired and attaining superannuation or otherwise against whom any departmental or judicial proceedings are instituted, right?
Yes, instituted.
Stop there.
Stop there.
Or where departments are continued. It qualifies under sub rule 2.
Yes.
It's not a question of saying that, like, so you understand what the court is trying to say. Then provisional pensions from 64 shall be sanctioned. How do you say that once judicial proceedings are instituted, that this rule not apply?
So far as the initiation of criminal and judicial proceeding is concerned, it has to be initiated prior to my.
No, how do you say that? Does not say continuing. How do you say that even if judicial proceedings are instituted before you retire and then does not say continuing, so this rule 64 won't apply? How do you say that?
Lordship rule is
that this court would not accept.
I'll clarify with only what is the effect of non-mentioning of continuation.
No, what impact will it have? No. If you take in the holistic definition, okay, they say departmental or judicial proceedings are instituted, or where departmentals are continued. Departmental proceedings are continued because why? In some cases, when a person retires, maybe it's closed and that is done. But criminal proceedings, you cannot be closed just like that.
That's true.
Department proceedings under the hand of the appointing authority, it's the authority itself. That is why it's qualified like that. Yes. Does not mean that just because it's just a judicial proceedings and department proceedings will be continued, that will be given the provisional pension 64.
My lordship, my simple argument is that, lordship,
it's not simple at all. You make it very complicated.
Yes, lordship, that on the day when the proceeding was initiated against me, I was not a government servant. I was a pensioner.
So when those proceedings instituted against you, judicial proceedings, were you already drawing pension?
No, lordship.
No.
No.
So when was instituted the judicial proceeding?
Judicial proceeding, my lord, FIR was filed on May 2014.
When did you retire?
31st January 2014.
So 31st January retired 2014. Then FIR was. I mean,
After 5 months.
they saw after 5 months.
After 5 months. Then, Lordship, the case was charged in 2016. Then cognizance was taken September 2016, Lordship. Then there was no whisper. I have pursuing to get my pension.
Now what's happened to proceedings? Still going on?
No, now the proceeding, like that is why, my lord, that culminated into the acquittal of the petitioner, Lordship.
So then what are we arguing about? Then give him his pension.
Now, Lordship, I am praying for interest, Lordship. On the earlier occasion, I have relied on judgment. My lord is not fully convinced with the judgment, so my lord has asked the parties to bring some more judgment only with regard to the issue. If the criminal proceeding culminates, culminates with the acquittal of the accused, then in that eventuality, the fault can be attributed to the department.
Where does it say that? How can it be culpable? Once a crime is detected, FIR is filed, now you acquitted, that means suppose a person is kept in jail for wrong.
I have relied on judgment, my lordship.
Yeah, I guess. Let's see what's the judgment.
It's in the file, lordship. Otherwise, I'll submit bullet submission, only 2 issues, lordship.
No need bullet submissions. It's just oral submissions enough. 2003, 2013.
No, Lord, 13 years, lordship. 2013.
You're not given the list of books today.
It's in the file, lordship. I have on the earlier occasions. YK Singla.
What is the name of the party?
YK Singla versus Punjab National Bank and others.
YK Singla.
Singla.
Not here, Mr. Sheikh. I'm sorry. This Punjab Haryana High Court is there. And some Punjab service rules are wide here. You see the judgment, Mr. Shulai?
Lordship, yes. I think that will not be applicable, Your Lordship.
No, wait. The court does not have a judgment. How will you know it's applicable or not? With regard to definition of judicial proceedings?
No, Your Lordship. This is a case regarding interest on delayed payment of gratuity, Your Lordship.
Here in this case,
can I have the the book?
I'm giving my copy, Lordship.
No, you didn't give it, Mr. Sheikh. You gave some Punjab Civil Service rules and some Punjab Haryana High Court judgments.
I have relied that judgment of the previous occasion. My lord was not fully convinced. So asked me to bring some more judgment. I got one more judgment, but that also not.
You are not convinced with that also. Yes.
Bank employee. What is this? No, this will not. This will not be up. This will not be up.
So you have paid provisional pension, correct?
No, lordship. That also not paid. Only they have paid only for 6 months. After that, they have not continued, lordship. So that too also, lordship. I filed it. Then court has directed to dispose of my representation. Then representation was not disposed. Then I filed contempt. Then during the pendency of the contempt, they have passed the order saying that no, we will grant you only provisional pension because you are facing some trial. So till the order passed for provisional pension, there was no whisper by the department saying that.
Okay, one thing, Mr. Sheikh, in the disposal petition, do you want the court to address that issue? So regarding judicial proceedings continuing, or what is the definition of judicial proceedings? You want the court to touch upon that point also?
No,
Or are you limiting your prayer now only to the extent that whatever's happened, fine? The application of Rule 64 is wrong, and now that you've been acquitted of all charges, now that your pension should be paid and you should be given interest on the delayed payment pension. That is the only case now.
My lordship, yes, I have two issues, lordship.
You have two.
Yes.
I'm saying that is not limited prayer. Then what other issues you have?
True, lordship, same lordship. Since the order passed by the department was illegal, because they have wrongfully,
What are you accused of forging a check, right?
Yes, lordship. They have wrongfully withheld my pensionary benefits, so they cannot, and they ought not to have the power which they have invoked while withholding my pensionary benefits.
So pensionary only gratuity.
Gratuity and all, my lords, and even pension, lordship. I got
Gratuity fine, because like Payment Gratuity Act provides that delayed payment interest is payable. But in the other circumstances,
this judgment, lordship, the division bench has restricted the payment of interest on the payment of gratuity. Then matter went to the Supreme Court. Then they have interpreted the word fault as mentioned in the payment of gratuity.
let us see then. Which you don't have the book with you anymore. It's there.
Yes, lordship.
No, not Payment Gratuity Act. This judgment.
Judgment, I lordship.
2013, 3 SEC 472. I don't want to keep any CAV actually, because I will not be here. That's the only thing.
Some other day.
We can do some other days.
Some other day.
I'm a bit busy also preparing.
My lord, only my prayer on the previous, or my lordship has passed the order that pendency of the writ petition shall not be a bar. Since now, so far as the payment of my pensionary benefits, they are not objecting, my lord. If there is little direction is given, I have put up my application along with the last order, lordship. And previous also I have filed my representation. If some sort of up to the convening of the department, lordship, so that that matter can be heard anytime, lordship.
Pay pension at least, whatever.
In fact, lordship, we have asked the department to do the needful. I don't know.
How will he survive?
Going to be 10 years, lordship. Had I received the provisional pension also, the thing would have been different, lordship.
Right. This court, by order dated 26/4/2023, had observed that in view of the acquittal of the petitioner, there should be no hindrance,
impediment,
in spite of the pendency petition, for processing the terminal benefits due to him. Stop. Next paragraph. Ms. S. E. Sheikh today has submitted that in spite of the direction contained in the aforementioned order, the respondents are yet to process his retirement dues. Stop. Though the prayer now in the minute petition is limited to the grant of interest on retirement benefits, it is expected that the respondents shall process the interest. We can order later.
Yes,
process the release of the term benefits pension payable to the red petitioner immediately. Mr. Andy Shulai, AG, to be given a copy of this order.
Lord.
Yes, to ensure compliance.
Lord.
Highly obliged. Highly obliged.
Obliged.
This is matter after 4 weeks.
4 weeks. Lord.
13.
Obliged, Lord.
Please, Your Lordship. Lord, by an earlier order in this, we were allowed an opportunity to file a rejoinder to the affidavit which they have filed, and they were also allowed to file an affidavit to bring on record the developments, recent developments. So, that
where is MS Colney?
Here, a little while ago. On the last date, she had asked for time. No, last date we asked.
No, last date because you were not here
I was
for
not
2-3
there.
occasions.
So my only submission, my lord, the affidavit, whatever has been permitted, my lord, some time may be given to exchange.
Yes, sir. Where's the respondent? At least somebody come forward on her behalf. I think there should be, a standing order that phones should be deposited outside. Because lawyers I've seen, young lawyers, they don't observe the court proceedings at all. They're all playing with the phones, non-stop. Sitting from here, I can see each and every one. They're all playing with the phones.
So mobile junkies now, new generation is.
No, I mean at least when we were juniors, not that maybe we're ancient now. The thing is that Ashina said, look, you don't have anything to do. You sit in the court, observe proceedings. That's how you learn. In the the discourse that goes on.
Read the judgments.
Don't read the judgment. Just listen to the arguments. Observe it, and then you imbibe, unconsciously imbibe also. But now I think you don't need it because I notice all the juniors, they just sit, all their heads are down. And they don't know what's going on. Even the matters are called out, sometimes they don't know. Which is very unfortunate. When the matters are called out, it's suddenly, oh sorry, I missed it.
Sensitize, we have to sensitize, it's our now sensitive.
Something has to be done, I think.
We have to do something.
It's like, you can't blame them also because we are all...
I'm facing with problem with my son, everybody is this new generation problem.
I bring a phone and chat, I'm listening to it, hearing start checking for messages, WhatsApp or something.
Concentration lapse, that's it.
Anyway, you're supposed to file some affidavit.
In terms of last order, my lord, rejoinder was required to be filed by you because...
So what I'm submitting,
yes,
there was an opportunity given to the for bringing on record the latest
promotion orders,
whatever developments.
Yes,
promotion orders. If that is brought, then I will file. If at all required, I'll file the rejoinder.
The issue is very short one. If I can simply, they have challenged the change in the policy, which made promotion from merit to seniority. And that policy has now been reverted. I am informed that earlier policy, my lord, was of June 2000.
Which is challenged.
That policy is under challenge, my lord. So that policy has now been withdrawn, if I understand correctly, my lord.
Somebody has reservations against that.
So, then it may be taken up for hearing.
They'll fix it, then we'll hear it, yes.
Any convenient.
Then Mr. A. Kumar, AG, appearing
the
for
matter
the corporation.
To an extent become infectious. Why, my lord? Because we'll place it.
Submits that no effort be forthcoming, no effort will be necessary in as much as the policy under challenge has been withdrawn, stopped.
Has been revised.
Have been revised. So, Mr. S. Chakravarti, Learned Senior Counsel, appearing petitioner has voiced his reservations. This is matter for hearing on soon.
Obliged.
14.
Lordship, I was supposed to file the rejoinder, but unfortunately,
what happened?
Due to bereavement in the family, Your Lordship, I could not.
How many times you asked Mr. Sabha?
Your Lordship, last time was the first time that I asked.
Last was first time?
Yes, Your Lordship.
What I am instructed to say, third time.
No, Your Lordship, it was the first time.
Okay, Mr. D. Sabha, in interest of justice, granted for the 3 weeks time to file rejoinder. This thereafter.
Highly obliged.
16.
See, the court not take any matters where judgment have to be reserved.
Beg your pardon, Lordship.
This court today will not take many matters where judgments have to be reserved. That's the only thing. If the long argument, judgment has to be reserved, records are there also, no?
Yes.
Then that will not take up the matter because I'm under some personal difficulty with the court.
Yes.
It'll take some time, correct?
Yes, Your Lordship.
Yes, due to Lisa's matter also. It's been heard in part, no?
It was partly last time, my lord has heard partly.
What was the point? Very interesting point.
It's about electricity connection, my lord. Restoration of
So,
electricity connection.
And again, it's a matter related with section 151 CPC. And regarding
yes, where without filing statement, they are subverting the process and filing other 151 applications.
151 application
Because we haven't gone through the details of the judgment, which was passed in the civil appeal, Your Lordship. So then I need to apprise much more.
Basically, my lord, their issue is
made.
that I should not have filed an application under section 151 for restoration of electricity in the tenanted premises. I have other alternative remedies which was not availed. Therefore, the order passed by the trial court was wrong. That's their issue, basically, my lord.
But is it correct? You never filed written statement in the trial court also?
My lord.
You never filed written statement also?
I have filed written statement. I have filed show cause also. It's on the record, my lord.
We've already filed an application on the order 8, Your Lordship, for rejection, because they have filed way beyond the mandatory period of filing written statement.
Court has accepted. Order has been passed.
No order has been passed. We haven't received any.
Written statement is appearing in the case record. If Your Lordship will produce, the written statement has been filed.
Interesting. We'll hear it some other day.
Okay.
Yes, this is a matter of... Yes, sir.
Good night, ma'am.
19.
Where's AP Hasana? None appears on behalf of the petitioner. This is matter for 3 weeks.
22.
This is that Provident Fund matter, Your Lordship. Lordship has heard the matter last
So she was supposed to obtain instructions.
Yes, Lordship.
What happened?
Lordship, I would like to take your attention to the affidavit I have filed, Lordship.
No, instructions on what? Why do you take time last time to obtain instructions?
7C, regarding 7C.
It was in the course of hearing, correct?
Yes, Lordship. Regarding 7C, there it was saying that the 7C is determination of escaped amount. On determination of escaped amount, how on previous...
If I remember correctly, Mr. Sen's case is that amount already lying with you.
No. It is with Shillong Municipality. No.
That is what?
The amount lying with is in Shillong Municipality. Here,
what
sorry. Okay.
No, here is the case, my lord, the period for which it was already settled, that too at the intervention of the court, my lord, that they have reopened, which they cannot do it, my lord. I have read those judgment of this honorable court, at the intervention of this court, money paid. After 20 years, that period was also reopened. Can they do it?
Lordship, regarding that only. Lordship, now the thing is that there is escaped amount. Here it is totally different. Whatever we have taken the recognizes under section 14B and 7Q. So 14B and 7Q, there is no time barred, Lordship. So during the previous, in our order only, we have reflected that during the previous demand notice, we have not, since that was not taken into consideration, so it can, under 14...
It comes under escape amount.
No, it is not escaped amount.
Then?
Escaped amount is, Lordship, is only with regard to order passed under 7A and 7C. Okay. If only under 7A and 7C order is passed, then it comes under escaped amount. But 14B and 7Q, there is no time barred, Lordship.
Okay.
So I have, in my affidavit, I have already reflected, Lordship, that the confusion, whatever the confusion has arose regarding 7C.
Where is that, where we submit the statement?
Affidavit is my affidavit, page number 9, Lordship.
Have you filed a jointer to it?
Yes, Lordship.
You haven't filed a jointer?
No, he has not filed a jointer. He has not filed a jointer.
Then if that is the case, where we explained it?
I have explained in page number 9, Lordship. Page number 9. For the wage month of 10...
No, I mean you're resorting to damages and interest, that means.
Yes, Lordship. Only we are resorting to damage interest.
Page 9.
Page 9 of my affidavit.
Yes, but read what do you say?
For the wage month,
yes.
For the wage month of 1097, it can be seen from the challan submitted that the belated payment of PF dues pertains to arrear payment of PF dues by the employer, whose delay in payment was not taken into account in the previous damage notice, and hence there are no overlapping of damage dues. Further, from the contention made by the employer establishment, it is clear that there is confusion between the assessment of PF dues under Section 7A and the penalty imposed for the delay in payment of PF dues, as the determination of escaped amount under Section 7C is the only relation to the assessment of PF dues made under Section 7A. So 7C is considered only if the order is passed under Section 7A.
So you say that you have taken to say this is only 14B.
Only 14B. It's only 14B, Lordship. In the order sheet also it is reflected in the order which we have passed, Lordship. In the read petition, the order is there, Lordship.
Why didn't you argue this last time?
Lordship, actually,
You were not prepared.
I was not fully prepared.
That is why.
Lordship, the matter we have taken into consideration is...
Where's the impugned order?
Impugned order is page 84 and 85.
Where is it clearly written for 14B? '84 and 85, okay.
In the first, in the matter of an enquiry proceeding under Section 14B and 7Q. So we have taken enquiry proceedings only under 14B and 7Q.
But after 20 years, what about a doctrine of reasonableness? Do you have any other cases which show that in such matters you have been successful in?
Yes, Lordship, in even with 25 years also we were successful, because there is no time limit.
Statutory bar.
The statutory bar, no time limit, Lordship.
Just read the findings, why damages were imposed.
The submission made by the employer.
Where is that?
It's page 2, almost last side, last para.
Okay, the submission made by employer.
Yes,
Yes,
the
okay.
submission made by the employer has been examined with reference to the material on record, rule provision and the laws laid down in this regard, and it has been found that for the wage month of 1997, it can be seen from the challan submitted that the belated payment of PF dues pertains to arrear payment of PF dues by the employer, whose delay in payment was not taken into account in the previous damage notice, and hence there is no overlapping of damage dues. Furthermore, from the contention made by the employer establishment, it is clear that there is a confusion between the assessment of PF dues under Section 7A and penalty imposed for delay in payment of PF dues, as determination of the escaped amount under Section 7C is only in relation to the assessment of PF dues made under Section 7A. As the current enquiry relates to damage only, wherein there has been actual delay in payment of PF dues for the present period of enquiry, and the amount of which have not been included in the previous demand notice dated 4/2005, and also since documentary evidence has been submitted to show that PF payment has been made on time for the contested period, the contention of the establishment is therefore rejected and the instant case is therefore closed. Lordship, next page. It is the statutory obligation of the employer to remit the PF provident fund dues and other charges within 15 days from the date of close of every month, but the employer has failed to remit the dues for the said period within the stipulated time. The employee's provident fund has to comply with the statutory obligation and has to give interest to its subscriber's account, whether the employer has remitted the dues in time or not. Because of the belated remittance, the Employees Provident Fund organization has lost interest which it could have earned by investing the amounts in government securities. Moreover, it is necessary that the damage under Section 14B are levied with the twin objects, namely reoccupying the loss sustained by the organization and also to have deterrent effects on the employer not to commit such default in future. Now, Lordship, here what happened, they have already committed such type of offence previously. This is their second offence, Lordship.
Even then, but you see, this is what the court defines as term. The employees provident fund is complied so and so, and could be earned by investing the amounts.
Investing the amount in government securities, because this we have to invest the amount to give at least now.
Where's the earlier High Court order which has closed the matter as per the submissions of the counsel for the petitioner? This is Annexure 7.
Annexure. It's page 65, I think. 64 and 65.
There's one decision also, I think Supreme Tires, you're aware of the decision. Have you got the decision regarding this problem? In this matter, if I'm not mistaken?
Oh, my lord, no, regarding
damages and interest.
No, damages and interest, I have some decisions, my lord. I have brought it. My lord, if I can clarify a few points, your lordship, this has been reflected even in the earlier judgment.
That is
now,
what
my learned friend is saying.
Trying to see whether that, 14B has already been incorporated in the earlier assessment, like even for the, there was a wrong committed at the event another account, correct? The amount was there, and so it came to court and it was reduced by only 25%.
Right. That is also damage and interest.
Yes.
Damage and interest.
That is what?
No, my lord, we'll see one thing. No, one thing, perhaps your lordship, my lord, that is not placed properly. The dues can be under 14B, dues can be under 7Q, dues can be under 7C. So many dues are there. Now, how these dues are determined? Dues are determined by a proceeding initiated under 7A. That has been reflected in this judgment. Lordship will come to page 66.
That is what
court has held, my lord. In the top, lordship will come. While letter dated such in the month of October 2002, the respondent number 3, however, initiated a proceeding against the petition under section 7A of the Act to ascertain whether all the dues, any kind of dues are to be ascertained by initiating a proceeding under 7A. And in the process, my lord, while issuing the notice, my lord, if any amount is escaped, whether under 14B, 7Q, anything, my lord.
Understood. We'll have it some other day because I don't have time to pass judgment today.
And so 7A is the actual proceeding to determine the dues.
No, because I wanted to get clarification from her only. Because she took time to take instructions. Now she says that it's independent. There's no time bar. It was under 14B. It's not an escape amount of 7C. It's not an escape amount where maybe they can come back to reassess.
I have got a decision, of course. So far 14B is concerned, my lord. Suppose proceeding was not initiated at all. There is a delay. Supreme Court said Limitation Act will not apply. Yes. There could be a delay. But if there is substantial delay, the defender can, my lord, point out the prejudice.
Your case has different footing altogether, Mr. Sen. Because your case has already been adjudicated
by the court
for the same assessment period by the court. It's a judicial order. That's why we have to look at that in that perspective, not only in perspective of the Act itself. See, what will be granted to them by the order, we have to examine that against your provisions. And the action that you took subsequently, inflicting the damages. That's the only thing.
And the other thing also, my lord, I'll try to explain, my lord, the 7A, what is 7A? Any interest is to determine under the prosecution. So notice issued, even regarding damages, my lord, if it is escaped, 7B will come. That I'll satisfy.
Anyway, this is a matter for further hearing.
There's some kind of interim order, my lord, that should continue.
Yes.
Otherwise, again, I don't know.
This is a matter for the hearing on June. We'll have it 19th. Yes.
June 13, up to June 13, I am occupied, Lordship. Because
Okay, then we'll have it in after 4 weeks. Then.
Okay.
The interim order continues.
Interim order shall continue.
Obliged.
For the order.
Lordship, we do apology.
Yes.
Lordship, we do apology. My action number was 99 is the item, Lordship. I am from Guwahati.
Oh, it's already been adjourned, Mr. Saranya. Yes.
My lord.
Yes, sir. It's a hearing matter.
Yeah, my
You know,
lord.
today we have some problem hearing matters. Yes, we'll fix a date. Yes, thank you.
My lord. Obliged.
Obliged.